we will present you the result of our research in the framework of the LHI project. So in the framework of the project, as Agne told this morning, we've led desk and field research in Lithuania, Belgium, and Albania. So first, Ruta Väikkönen and Simonas Nikartas will present, I'm sorry if I didn't pronounce your name right. It's the, with international project, we have to learn. So we'll present you the research in Lithuania first. So Ruta Väikkönen, you're a senior research fellow and head of the criminological research department at the Law Institute of Lithuanian Center for Social Sciences. You're currently involved in two international projects which aim to contribute to strengthening protection of procedural rights of children in conflict with the law. So the Legal Aid for Children project and the Child project, so which is an individual assessment, and that maybe many participants can be interested by this second project too. And Dr. Simonas Nekartas, you're a researcher in law and criminology. You hold the position of the head of Criminal Justice Research Department in the Law Institute of Center for Social Sciences of Lithuania. You're a member of the Lithuanian Society of Criminology and the former president of this organization, and you had taken part in a number of national and international research projects and authored about 30 research publications in Lithuania and abroad. And I will give you the floor, Ruta and Simonas, for 15 minutes to present the research in Lithuania.
Thank you, Eva, for your presentation, and hello everyone again. Yes, I'm uploading our slides. I hope you can see it. And yes, as Eva already have told, we will present our project research results, me and Ruta especially, about Lithuania. Our research included two main methods. First one was a desk research of different practice and legal regulation of European countries, so legal aid and legal aid for children. And the other method, and I think this is also it's very valuable method. It was interviews, it was qualitative empirical research, interviews with stakeholders and experts in the legal aid field. I will present first very shortly the introduction to the context to the system of legal aid in Lithuania and some main legal guarantees for children of legal aid, and also some main insights to the from our desk research. And Ruta will present the results. The most interesting part of this presentation, of course, the result of qualitative research of interviews with stakeholders in Lithuania. Speaking about legal aid system in Lithuania.
Simonas, I'm sorry
Yes.
to interrupt you. Maybe can you put your presentation in full screen? We see the PowerPoint interface.
Now, okay. Now you
yeah,
can...
now it's perfect. Thank you.
So, speaking about Lithuanian legal aid system, we have two levels of legal aid: the primary legal aid and secondary legal aid. Primary legal aid, it also could be called in English the first line legal aid, includes legal advice and drafting of the documents to be submitted, for example, to state and municipal institutions, with the exception of procedural documents, and it's provided for free of charge by municipal institutions. Usually the main practice that employees of municipality who have uh, law background at or university, not lawyers, but like employers with law education at university, and they provide usually advice for all people interested. And this is primary legal aid is granted irrespective of person's financial situation. And secondary legal aid is provided only by lawyers, in some advocates, in some cases also by their associates, and it is funded by the state. It covers legal aid services uh, as representation in courts, and also preparation of procedural documents, especially documents for the court, and the legal aid lawyers. There are two type of legal aid lawyers. All of them are appointed by a Lithuanian legal aid service. Uh, what, the first type, there are lawyers who continuously provide legal aid. They don't work in private cases. They only work for legal aid cases, and they are and they have receive salary from the state. And the other type, there are lawyers who provide legal aid in case of necessity, ad hoc in cases, and who otherwise have their private practice. This is very shortly about system, about legal aid general system in Lithuania. Speaking about the child's right to the legal aid, the law on state guaranteed legal aid provides that children in conflict with the law, suspected or accused children in criminal proceeding, have the right to receive secondary legal aid regardless the levels of property. And it's also because of mandatory representation of suspected or accused children in criminal proceedings provided by the Article 51 of Code of Criminal Procedure. The Code of Criminal Procedure also provides uh, mm, restriction of waiver of the lawyer in criminal proceedings. It establishes that the pretrial investigation officer, prosecutor, or court are not obliged to accept the waiver of the lawyer from the minor. There are also some provisions for foreigner children, but I will not stop on them because I promised that I will speak shortly, and I want to give more time for Ruta. Uh, Speaking about our desk research, uh, it it could be said that we find of course a lot of things, but in few words, what can be said? In speaking about Lithuania, we can see that all suspected children are guaranteed by legal aid, and the regulation is quite good. But always, as we speak about children rights, we maybe all know that principle of priority of child interests, and we see it established in laws and of different countries. Uh, but when we start looking into the practice, and it is not only about the legal aid systems, I think in many fields, there is a common feature that, uh, it's my opinion, I often see that very often the priority of not of the child, but priority of adult interest prevails. And similar conclusion could be given also speaking about legal aid systems. Now I'll speak more about Lithuania, but we can also see that in many countries that, for example, in Lithuania, we have quite, as I already mentioned, good regulation, but there are some shortcomings in practice, in practical implementation. For example, our desk research revealed there is a lack of specialization and training of lawyers, but also of other stakeholders in criminal proceeding directed to the aspects of children rights and or etc. There also lack of quality assessment or insurance instruments. This could be said not only about right of children, but about in general many legal aid system lack of effective quality assessment instruments, and also we also, it's important because also directive establishes that that not only the formal provision of legal aid is important, but also effective representation of child, effective legal aid is important according to the directive. And also what uh, uh, we can see that there is a lack of, how to say, the of measures of provisions of regulation adapted to child, like friendly forms of providing information to child, etc. Our systems, I see that they are still very adapted to adult interests. There are very few special provisions, special regulation and measures for the childs. It's my view, it's my opinion, what I saw during our desk research. About other problems from empirical research field will be presented by Ruta, and I give the word to her now. Thank you very much for listening.
Do you see my presentation?
Yes, perfect, Ruta.
Okay, so Simonas already mentioned that we did qualitative research using the same methodology in all three countries, Lithuania, Belgium, and Albania. And now I will continue by presenting empirical data, which was gathered during semi-structured interviews with advocates providing legal aid service to children in conflict with law and prosecutors. So we conducted in-depth interviews aimed at discussing, let's say, macro and micro levels questions. I mean, during the interviews, in one side, legal aid system was discussed and analyzed. For instance, requirements and standards, training and skills of legal aid providers, assessment of lawyers' work of quality. And in the another side, we discussed, let's say, more micro level questions. um, um, about daily experiences while providing legal aid for children, about contacts, relations, role of advocate, and so on. So now I will try shortly present empirical results, and we try to conceptualize views and experiences of lawyers which participated in our research and identified two approaches. The first I entitled approach, which is more oriented towards justice model. And the second one I entitled approach, which is oriented towards welfare model. So I will start with the first one. So what does it mean oriented toward justice model? The research revealed that part of advocates, as you see in the picture, focus more on providing legal aid in its strict sense, treating it exclusively as a defense and assistance process. They see more formal and narrow objectives of the child's legal protection. In their opinion, legal professionals are sufficiently qualified and can ensure the procedural rights and interests of children. They believe that special knowledge and skills come along with extensive work and experience, so the need of special trainings or specialization is minor. Moreover, these lawyers doubted that different specialists like psychologists, social workers, and institutions like Agency of Children's Rights Protection should be involved in every single case. As well, they state that cooperation with other specialists is not very intensive in their daily practice. The research revealed that lawyers which were attached to this approach in most cases provide legal aid as permanent advocates. And they have very extensive workload. They've forced to jump from one case to another. And finally, we notice that these permanent lawyers lack of motivation, maybe as I mentioned, because they're dealing with a lot of cases at the same time and do not have ability to go deeper. And here we have another approach, which, as I mentioned, I entitled them, it oriented towards welfare model. And here advocates emphasize that mostly they deal with the minors from the deprived social environments that lack attention from parents and close relationship. These children do not feel safe neither in relation with their family nor to the state. Distrust, hostility, and isolation become children's natural defensive reaction to the provision of state-guaranteed legal aid. For this exact reason, it is essential for an advocate to build a proactive connection and relationship based on trust and sensitivity. So as you see, these lawyers focus not only on implementation of primary, more formal and narrow objectives of the child's legal protection. They define that the final aim working in team with other specialists is preventing minors from committing new crimes in the future. This aim was named as a main source of motivation. In order to reach this aim, specialized knowledge and coordinate work in multidisciplinary teams are essential. Finally, this approach was emphasized more by on-call advocates, which have opportunity to limit the amount of cases. So you see two different views, and now I will try to summarize by presenting what are the main challenges for ensuring high quality legal aid service, child-friendly legal aid service in Lithuania, and what are the prospects for the further improvements. So first of all, according to research participants, remuneration for their work does not motivate them sufficiently. The main problem constitutes not the or hourly rate, which is also very low, 16 euros per hour. But the main problem is rather the recording of advocates' working hours. The number of hours assigned to both permanent and on-call advocates for the execution of a particular task is limited. So in practice, hourly rate remains constant regardless of the efforts made. So research participants emphasize that it demotivates them. So another important question is assessment of quality. Simonas also mentioned this problem. Currently, the main quality control mechanism is evaluation of complaints received from legal aid recipients. However, having in mind that recipients are children, complaints often are made in exceptional cases. Therefore, they cannot be regarded as a systematic and targeted assessment. So actually, it could be summarized that we do not have systematic assessment of advocates' quality of work. And finally, according to research participants, the main elements that could enhance lawyers' motivation are specialized trainings, coordinated cooperation with other institutions, and, as already been mentioned, improvement of remuneration system. So these are the main views that lawyers shared with us. Thanks to them, and thanks to you that you listened to us.
Thank you, Ruta. Thank you, Simonas, for your presentations. So I just wanted to tell you that after the presentation on Belgium that I will do right now and the presentation of Agnieszka on Albania, we will do a little, we will launch a poll and asking you 2 or 3 questions so we have idea of how it is going on your countries. And then we will do the question and answer session. So I will present you the research in Belgium and start to share your screen. Okay, I think you see my screen right now. So my name is Eva Gagneux. I am an advocacy officer and project officer for Child Justice Project in DCI Belgium. And I will present you the legal aid for children in conflict with the law research in Belgium. Maybe first of all, a little precision on the scope of the research. So we will focus on legal aid for children in conflict with the law. During the research, we collected information both on primary and secondary legal aid, but in this presentation, I will only focus on secondary legal aid. And when we talk about children in conflict with the law, we talk about children who are suspected, accused, or condemned for an offense. And at the time of the offense, these children were above the age of criminal responsibility, but under 18. So as Ruta and Simonas explained, during the LHI project, we've led desk research and interviews of professionals. So in Belgium, we interviewed 15 professionals. 11 of them were youth lawyers. So youth lawyer in Belgium, they represent both children in conflict with the law and children who need protection. And 4 of the interviewed professionals were people who managed the legal aid offices, and 2 other professionals were social workers who work for an organization who provides first-line legal aid. And here is the picture of our national reports, so you can download all the national overviews we've done on our LHI website. First of all, I will start with some key information on legal aid for children in Belgium. So first, secondary legal aid remains a federal competence in Belgium, but it is organized locally by legal aid offices, and legal aid offices are organized in each bar association. Secondly, in Belgium, children are assisted by specialized lawyer who are registered on the youth lawyer list of their bar association. Then children in conflict with the law have always the right to free legal aid, to completely free legal aid. It does not depend on the means of their parents. And then all children in conflict with the law must be assisted by a lawyer from the beginning of the procedure and at every stage of the procedure. And as it was mentioned by many participants, the question of the waiver, I will precise that in Belgium, children in conflict with the law cannot waive the right to be assisted by a lawyer. So first, the designation of a lawyer for a child, when does it occur? Well, when it can be at many stages of the proceedings, but it can be because a child have to be heard as a suspect by the police, or because the child have a hearing with his or her judge, or at any other stage of the procedure when people realize that the child have no lawyer yet. And most of the time, when a child needs a lawyer, these are the legal aid offices who are informed by the authorities, by the police or by the court, that a child needs a lawyer. And then these legal aid offices will follow guiding principle to designate a lawyer for the child. The first and most important principle is that if it's a child, he needs a youth lawyer, so a lawyer who is registered as able to represent a child. Then these legal aid offices respect the principle of the free choice of the lawyer as for adults. So for example, if they designate a lawyer for a child, but this child already know a lawyer because he or she has a friend who has a lawyer, then the child has the right to ask the legal aid office to designate the lawyer he or she wants. Another principle is the continuity of the lawyer. So we know how important a relationship based on trust is important between the lawyer and the child he or she represents, and how unpleasant it is for a child to always repeat the same story when he or she meets new professionals of justice. And so some of the legal aid offices in Belgium, not all, but some, really ensure that the principle that we have one child, one lawyer. So if the child already met a lawyer in a previous procedure, they will try to appoint this same lawyer. Then during the interviews, we wondered, but what about, so this first matching of if it's a child in conflict with the law, he needs a youth lawyer is really important and it's fundamental. But then we asked to the professional, but maybe sometimes children in conflict with the law have other special needs. For example, a child in conflict with the law might also be a foreign children who have needs in terms of proceedings for asylum or whatever. And then another idea would be to select for this child a lawyer who has these two hats, the one of a lawyer for children, but also who is competent in foreign law. This is not a thing that they do regularly in Belgium, but on an ad hoc basis, some of the legal aid offices try to do this when they identify these needs. And when we've met this professional, the first question, well, not the first question, but one important question we asked them was, what is the role of the lawyer for children in conflict with the law? And this quote of a youth lawyer in Belgium reflects all the response we gathered. And she says, your role is to be the child's spokesperson, really ask him what he wants to ask and tell the judge, and then help him say it. Then uh, coming from this role, the missions they identified during the interviews was, first of all, to advise the youth, to inform, to listen to the youth, to help the youth, but also to guarantee the respect of their rights all along the proceedings, and to plead for the youth. And in order to fulfill this role, to complete these missions, we ask the professional, okay, but what do you do during the first meeting with the young, and what do you do during all the meetings with the young in order to complete these missions? And they explained a lot of things, but first of all, they said that during the first meeting, it's fundamental to well present yourself as a lawyer, and to present what is your mission and the framework of your intervention, what you can do and can't do, and maybe some key principle of your intervention, such as the professional secrecy. Secondly, and they said that it's really important to start to try to build the trust since the first interview, since the first meeting. And in order to build the trust, they all have various things they do. But first, for example, they will not use a very formal language, and try to be simple and familiar with the youth, and they will ask them if they are okay, if and other questions that are not directly related to the case. Of course, the lawyer said that they adapt to the situation. If they just have 20 minutes before a hearing with the police, they will not take the time to speak about all what the child like to do and everything. Then they prepare the defense with the child. And how do they prepare the defense? Well, they do a lot of things, but they mention that they all take time to really prepare the child to the situation he will face. And for example, to explain, so now you are going to be heard by the police. So policemen can do this and that. You have the right to do this and that. Maybe we can take a break and have a private consultation in the middle of the hearing, etc. Then they really said to us that giving information is important, and giving appropriate information to their youth clients is important. And how to give appropriate information? Well, they adapt to the receptiveness of every child they meet, and not only to their age, but to every child they meet. They try to give them also the most detailed and adapted information on the exact moment of the proceedings, not to drown them under hundreds of information, but really to give them the one they need in the exact moment where they are. And in Belgium, who are these legal aid providers? Well, first of all, and I already mentioned that the legal aid providers for children, they are lawyers or trainee lawyers who are members of the youth section of their bar associations. So in order to be a member of this youth section of the bar association, first of all, you have to volunteer, and it's really important. You have to have the willing to work with children. And in order to remain and to be in this list and to remain on this list, you have lawyers have obligations of undergoing an initial training and continuous training. Regarding the initial training, it varies from an order to the other, because in Belgium, there are two orders of the lawyer, one for the Flemish speaking bar association and one for the French and German speaking bar associations. So each order have their standards in terms of initial trainings, and then inside each bar association, um, each bar association can set higher levels of training required. And this morning, Sophie Debus presented quite a lot of information on the training of lawyers in Belgium, so I will not repeat all of it, but just to have an idea, for example, in Flanders, in order to be in this youth section, you have to follow first a training of 80 to 100 hours of class on law, mainly related to justice for children, but also civil or public law. And it is a multidisciplinary training also who involve psychology, criminology, sociology, and even communication exercises involving role play. So it's quite a broad training. And then all over the country, lawyers have to fulfill continuous training, and especially when they are lawyer for children, they have to have continuous training specialized that is relevant for their practice. And this continuous training can have various forms. It can be participation to lunch talks, webinars, maybe visit of the, I heard also visit of detention center for children, or any other activities that can be relevant. So not only law. During the interviews, we noted as a really inspiring practice the use of mentoring in some countries. In some no, not in some countries, sorry. I was trying to look at the type in the meantime. So in some bar association, when you want to become a youth lawyer, the first weeks or months, you have to follow an experimented youth lawyer. You will have to assist to some hearings with this lawyer. You will have to have conversation with this lawyer. And for your first case, you can ask him advice. The lawyers we've met especially said that this is important as a support and as more than a support regarding law, but as a support regarding the effects of meeting some children in difficult situation for the first times. We know and we understand that training of lawyers is really important, but why is it so important? And so we asked the professional we've met, what are the skills and knowledge you consider as required in order to represent a child in conflict with the law? And all of them started by saying, first you need to know youth law, because youth law is not the same as criminal law. So you have to know their particular procedure, their particular actors, and the particular philosophy of this youth law. You also need some competencies in other branches of law that will help the children you met. But this represents just only a percentage, maybe 50% of your work. And then they say that you have to have other skills, such as a good knowledge of the actors and institutions that are involved in the socio-educational field where you work. And concretely, we help you to advise the child on associations that can help him with school or other problems that can he or she can meet in his life. Then what they really insisted on are the soft skills, and especially two capacities. The first is to know how to talk to young people, and the second one, which is symmetry of it, to be able to understand the children and their situation. So understand and be understood by children in conflict with the law. And I will read this quote from a lawyer we've met, because she explained it well, I think. She says, sometimes it is essential to know how to understand what is hidden behind the words of a child and to be able to figure out on the basis of a few words what his or her real situation is, what his or her real will is. And being able to understand and be understood by the child is a real challenge they see, and a competence, a skill that is absolutely crucial. So how to reach this? They said that to reach these, they need elements of understanding that come from various disciplines. So the importance of multidisciplinary training. Here they mention, for example, psychology, criminology, sociology too. And they say they need also, and particularly, some knowledges in child development. Why? Because, and I will quote another person we interviewed, she says, we need to have knowledge in children's development, first to be aware of what is going on and when it is going on, but also because it is necessary to have some knowledge about the fact that children do not think in the same way as an adult. Then another very important part of understanding, being understood, is to be able of empathy. So it's not something you will learn in one training, of course, but being empathic is important according to this lawyer, and is something that you can work, of course, that you can train. Then also a lot of them mentioned that to understand the child, you need to understand what are the interests and the reality of the youth of today, because they evolve. And then also to have some skills in intercultural understanding, because children you represent will not always come from the same cultural background as you do. And then we identified some challenges in Belgium, especially the question of having various lawyers. Many children say it's not okay to have three lawyers for one proceedings, or many lawyers say and point as a challenge that children are still not informed enough about their rights. I will stop sharing my screen. Thank you for your attention. I will now give, it was the presentation on Belgium, and now I will give the floor to my colleague Agnieszka Puka from Albania for the presentation on Albania. So Agnieszka, you work for the Center of Integrated Legal Services and Practices, CILSP, in Albania. You're a lawyer, and for a long time you have worked and been part of several projects related to children's rights, and you are part of the LHI project staff. The floor is yours.
Yes, thank you for your presentation. Hello again. I will present to you in general the main points details to Albanian study. Okay, I have to, sorry, 1 second. It's okay now? Yeah. Okay. Okay, the purpose of this study is to produce a general overview of the legal framework regulating the children legal aid in Albania, their access to justice and access to right, as well as the instruments, mechanisms, and institutions foreseen by law to provide such access. The study focused either on positive developments or challenges related to the well-functioning of the legal aid system for children. Methodology. This research first is current legislation, including laws, sub-legal acts, decision of Council of Ministers, orders of ministers and other authorities. Second, the state statistic produced by the respective entities. Third is published research reports on legal aid and on access to justice for the national or international organization. Fourth is court cases and national strategies. Field research in order to have an overview of the current situation of legal aid for children in conflict with the law. 15 semi-extraction interviews were conducted with legal professionals. The interviews were conducted with 12 attorneys, 2 judges, and 1 prosecutor. Each interview lasts from 16 to 18 minutes. Code of Criminal Justice for Children. The Code of Criminal Justice for Children, approved with the law number 37, 2017, represents one of the biggest achievements for a new juvenile justice system in Albania. Code established the criminal justice framework for children, which is compliance with the UN Convention of Rights of the Children and UN and European international standards. Okay. It seeks to adapt the criminal justice system to the needs of the child for access to justice and legal remedies, protection, education, and rehabilitation for those in contact with the law. The intercode is focused in the philosophy of supporting the child's choice of life away from crime and violence, and guided by the convention principle of the best interest of the child. I'm going too quick, or it's okay?
It's okay, but maybe can you put it full screen, your presentation?
Okay, sorry. Okay. I thought this was okay. It's okay now?
Now it's okay. Perfect.
Okay, okay, I was. The code lists out for the first time the concept of free legal aid, accompanied by the concept of the state being the guarantor for such rights. In more concrete terms, code provides the free mandatory legal aid service shall be covered by the budget of the institution, who are obligated to cover the respective costs. Okay. Law number 111/2017 on state guaranteed legal aid. This law aims to create a system for the organization and delivery of free of charge legal aid in an effective and equal manner for all individuals in need. The law foresees for the first time the legal service to advise on the procedures of mediation and the alternative means of dispute resolution, trying to divert the case from the court to alternative dispute resolution. This is very important for the children. Okay. Albanian Justice Strategy for Children, 2018-2021. The proposal of Albanian Justice for Children strategy is to effectively protect the rights of children in conflict with the law, victims or witness of crime, children under age of criminal responsibility, through the interdisciplinary of national and international strategies of child rights. The strategy has an interdisciplinary approach, is provide elements with other existing national documents and contains concrete activities. The vision of the strategy is to improve justice for children, ensure a child-friendly justice through 5 strategies goals. The first is guarantee children's access to justice. The second is ensure fair trial for children, prevent re-involvement to children in delinquency, reintegration and social inclusion of children in conflict with the law, and fifth is build a capacity of the justice for children system structures. System of legal aid for children. There is no separate system of legal aid for children foreseen by the law. However, by creating the obligation of bar association to provide training, the law creates the premise to have specialized lawyers for children in conflict with the law and children victims of the crimes, as this represents special categories of beneficiaries that would qualify for mandatory defense. Bar Association approved a separate list of certified advocates that will deliver legal service for children after having conducted specialized training with a group of advocates. Bar Association has prepared a list with the trained lawyers on children-related issues, but is not being respected by the proceeding bodies to appoint only these lawyers in case involving children in conflict with the law or victims of crime. In practice, the only specialized advocates for children have been provided by not-profit organizations. Access information about legal aid. Based on the Criminal Code of Juvenile Justice, the child in conflict with the law is notified according to the rules foreseen in the Code of Criminal Procedure. The prosecutor and the judicial police officer must take measures strictly observing criminal procedure. Provision immediately inform the children directly of through parents, legal representative on the nature of an allegation against with him or her, the right to free legal aid, as well any other necessary assistance necessary. Despite on fact that the legislator did not include clearly the term of using a child-friendly language when communication with children, it has, however, stipulated the obligation that the information should be improprieties and understood by the child. However, based on interview results at the beginning of the interview with a judicial police officer, the child is provided with a Bill of Rights. There exists only one type of Bill of Rights for both adults and juveniles. This means that it's not written, is understandable language for juveniles. Therefore, it's not certain whether the child understands properly his or her rights. Interaction with the child in conflict with the law. The time to talk with the child before the interview with the prosecutor is often insufficient. Often the attorney at the law can meet the juvenile for about 10 minutes before the interview. Moreover, it happens that often that they cannot talk to them all before the interview. As a result, the lawyers never takes the necessary information, nor introduce himself and explain his role probably to the child. During the interview session at the police station, it happens quite often that the lawyer does not contact the police officer even when it is needed. He or she does not intervene when the interviewer asks an improprieties question, leading question or multiplied question that can mislead the conversation with the juvenile. Additionally, at the end of the interview, they accept to sign the paper despite the irregularities, of the interviewing process. If the lawyer would contact the police officer, he or she might not be referred in another case. Considering these facts, it can be assumed that often the role of the defense attorney is limited only to his or her physical presence during the interviewing session. The entire process is leading only by the judicial police officer in charge. The attorneys that define the juveniles are not selected from the list of specialized lawyers. There is no collaboration between relevant institutions on this regard. The lawyers who define the juveniles are usually selected based on the police officer or judge's preferences. What seems to be more concerning is the fact that the lawyer's address is issued to the relevant institution, Ministry of Justice, Bar Association. They risk never to get referred juvenile cases by the police officer. In most cases, the lawyer does not follow the juvenile throughout all the legal procedures. However, the lawyers that participate in the interviewing session at the police station are not allowed those who represent the child before the court. The legal professionals who work with children, including judges, prosecutors, and other attorneys, are not specialized on juvenile issues. They have neither the necessary information nor the right skills to deal properly with a child in conflict with the law. This constitutes a serious threat to the quality of the legal process. So, thank you for your attention.
Thank you, Anesa, for your presentation, and thank you very much because you replaced Claudiane, who was supposed to participate, and you just learned yesterday that you have to present the report today. Thank you very much for presenting it. Right now, so we will launch a poll to have all the participants' opinion, and not really an opinion, but input on two questions that we will ask to you. The first question is representation of children in conflict with the law mandatory in your country? Meaning, is a child in conflict with the law always assigned with a lawyer? And you can say yes, no, or I don't know. Then the second question we will ask you would be, is there a youth lawyer category in your country? Which means is there a specialization of lawyer who represent children? Tamas, can you show us the result of the poll, maybe? Ah, thank you very much. I see the result. So, is the representation of children in conflict with the law mandatory in your country? Yes, for 68% of the participants, no for a quarter of the participants, and I don't know for 8% of the participants. So, of course, I think most of us come from the same countries, so it does not give us a really good overview of the reality. But and then, is there a youth lawyer category in your country, which means there's specialization of lawyer who represent children, and it's almost 50-50. So it remains a challenge and something to reach. We have already a question for the panelists. And the first question, and I invite you all to write your question if you have some in the Q&A box. So the first question is to all panelists who would like to respond. As we speak on changing the mindset of legal professionals, I believe establishing this in the early years of the profession is crucial. What are the specific provisions and/or practices on pre-service training for lawyers during their internship? Is there any specific curricula on justice for children at that stage? Thank you all very much. And it comes from Mr. Goktan. Who would like to start? Maybe Agnesa, Ruta, Simonas. Please take the floor. So maybe I can start by responding with Belgium, but I think I've already told this during my presentation, so I don't want to take too much space with Belgium. But indeed, in Belgium, in the initial training, there is specialization of youth lawyer with many content on youth law and other multidisciplinary learnings. And there is this mentorship, which is not all over the country, but which is in some bar association, and that in order to be able to practice as a youth lawyer, have to start with an experimented youth lawyer, and for weeks or months to be with this lawyer, sometimes to follow them at interesting events such as hearings with children. Agnesa, do you want to add something on Albania, maybe on the first training and the specific provision for training during the internship of lawyer, maybe?
For this question, I can't respond it because I don't have, I don't know. I'm not the representative that can answer this question. So
yes, no problem, Agnesa.
I have to.
But of course, you will have the response in our European report that will be published by the end of the month, and you already have the response regarding Albania in the national report that is published if you want to take a look at it. Regarding Lithuania, Ruta?
I totally agree that changing of mindset, as you saw in our presentation, is very important, is crucial. But I am not sure, do we have some kind of service training for lawyers in internships? I don't know, maybe Simonas know more.
I know only that if you speak about training on about juveniles, about minors, it's only, as you know, is part of exam of lawyers in Lithuania that covers aspects of criminal justice for juveniles, criminal responsibility for juveniles. And as I know, there are. If I looked to the list of trainings, but it was hard to find topics about juvenile justice in Lithuania. There are some maybe trainings of psychologists, but there are really very few attention in trainings for topics related to legal aspects of juvenile.
And from Albania, Rezarta Abdu is telling us that in Albania, there exists a training session on juvenile justice in the School of Advocacy, same time with the internship. And Rezarta say to be one of the experts of the Albanian National Report. Thank you very much for participating through the Q&A chat box. We cannot give you the floor, unfortunately, but thank you, Rezarta. We are a little bit behind schedule. I think we need a coffee break, but I'm not sure it's in English. You can say it in English, but I will share the peer into two equal parts. We say it into French. So I will shorten a little bit the coffee break, but not too much. So I offer that we join again at 3:40, so in 7 minutes. It seems okay for the panelists and for the participants. I have no idea because I don't see you, but have a nice coffee break and see you in 7 minutes.